Hello, everybody, for now the third time today. If you were here for the earlier calamity, I do apologize. And also, you're welcome for that entertainment. I am here today with Christopher C. Belcher, Esquire, and he happens to also be representing USA Today as their attorney in an ongoing sort of case. I'm going to let him talk about it, or an ongoing petition where we have talked about on this channel before. We read through it. Christopher is making the case that it is actually in the public's interest and it is our right, our constitutional right, to be able to see and hear what is going on in the courtroom with Britney on September 29th. We'll talk a little bit about that today, and we will also talk about what Christopher's next steps and what he plans to do next after, as we know, Judge Penny has denied his original request. So welcome to That Surprise Witness YouTube channel. Christopher, thank you so much again for joining us. I am so excited to have you here. And obviously other people are super excited to be here. So why don't you just, introduce yourself and talk about, maybe, I don't know, what got you interested in the Free Britney movement, or anything else you would like to say.
Well, thanks for having me on the show. And I wanted to obviously talk about this appeal that I'm doing of the ruling to try and restore access so we can listen to the next hearing and other hearings that happen in this and other cases, but also just a little bit of background about like how I got involved and how this channel has helped me, because I've been in traditional media. I'm a total newbie to social media and YouTube. It's really recent for me. So I've been doing traditional media, which means speaking on network television shows and on doing legal commentary. And it really was your channel that I was first introduced to learn the facts about the case, because we see the headlines and that media matters stuff. And we should talk about that. The media matters has influenced the media, and it's very easy to get into that narrative and buy that story about, oh, Britney had a meltdown and she needed the help, and that's the conservatorship's all good. That story was being pumped out there successfully for a long time. And it was really, and I remember watching your video about the no notice, February 1, 2008. And it's like, I had no idea that happened. And once I saw that, it changed my focus. And now, I'm spending nights and weekends on Free Britney.
That is so cool to hear. Actually, as y'all are hearing, that's the first time I ever am hearing that too. So I don't know. It's you put a lot of time and effort into this work, and of course doing so with one goal in mind, right? Like Free Britney, never to kind of like, I don't know, influence other people or whatever. But it is so cool to hear that all of that work was able to help you, who's another lawyer with, a lot of experience in the legal profession, to kind of get your hands around the case. And in a way that's kind of like what we would be doing if we were at a law firm, right? Like the sort of junior associate, like looking up all the facts, and then the more senior person, if for anybody here for law firm facts, which I don't think many people are. But yeah, so do you want to walk through like a little bit about how you arrived at, filing this petition that you did file? It would have been about a month ago now, or it's hard to keep track.
Sure. So this, in monitoring Twitter, and we saw the court react really emotionally and punitively to June 23 and cutting off the audio access that we previously had to these proceedings. And I remember tweeting about it at the time, saying, this is just wrong. And I was also working with a reporter on another story. I think it was the Brangelina story. And we were also getting pushback from the court, or difficulty from the court there, on getting access to records in that story. And at least the last time I checked, in Brangelina and also in Kelly Clarkson's divorce, you go on the register, you type in their names, doesn't exist. Public case doesn't exist. And so you can't get this stuff, and it's supposed to be out there. And me and this reporter were talking about how difficult it is, because we want to report on real stuff, and we want to see documents to report on what's happening in this case, and we couldn't get it. And she said, yeah, it'd be nice to challenge this, but who's going to take that on? And that planted the seed in my mind. And I thought, well, gee, I'm a lawyer. Maybe I would take some of this stuff on. And that's when I started thinking about what they're doing in Britney's case. And then I went to start pitching it, and through all the media contacts that I have. And USA Today fortunately said okay. And this is something that I've had to learn in working with traditional media. You think that they're following these stories and way in advance. They're not. They're following, like September 29th. We all know, big day, lots of stuff at stake. The media mostly is going to be thinking about that, if we're lucky, September 28th and probably September 29th. There's a lot of freelance reporters. They're handling 5 stories at a time. So to get USA Today to say, hey, would you support us with this? Put your might behind this, because it's going to look a lot better if it comes from a major outlet, months in advance and all this. So very, very thankful that they supported that. And so we're working through, we went through stage 1, the LA Superior Court, and now we're going to the Court of Appeal.
It's interesting to hear that perspective of the story, because I mean, I think a lot of us know USA Today as that evil periodical or whatever, news outlet that kind of wrote this story about how Britney fact check doesn't need the conservatorship, or she's not being abused or whatever. And so for those reasons, we were all kind of like, USA Today like had a bad taste in our mouth. But now what to hear you say is they actually, maybe they did run that story, but they were, one of the only, if not the only, outlets to kind of step up to the plate and say, yeah, we will actually take this on because it is really important. So it's really helpful to have like sort of that perspective, because it really reminds us that not everything is black and white and not everything is evil or good or whatever. So I don't know, just life lessons along the way.
Well, and it's, my view of the media has changed quite a bit from seeing more on the behind the scenes part of it, because before I thought, wow, they have this big machine and a lot of reporters and producers and editors, and, which they do, and they get it right, but they don't always get it right. And with the change that's happened with social media really becoming the primary news source for a lot of folks, the traditional media under a lot of pressure. And so with limited resources trying to push out these stories, and let's not forget that they were being influenced by the conservatorship team. We know that $541,000 worth of influence that we know about for sure. And this has been going on for a long time. And I know that has had an impact, that they did infiltrate the media and plant stories and leak stories. And that's how basically these things get perpetuated. That's how TMZ operates, is through leaks and then putting out this story. So if you have a leaker, they're going to be able to manipulate the story. And that's what happened. And there was only one side pushing information, and that was the conservatorship team. So not good moments, certainly for the media. They were fooled. But I do believe that reporters understand that they were contacted by the crisis manager, that stories were being leaked by the crisis manager, that some of those probably got printed, and now they feel burned. And now things are different. We're seeing better stories now come out of the media. So look, it's not a perfect world. Like you say, it's not all right or wrong, but hey, all we can hope is we get it better next time.
Yeah. Oh, thank you so much, Jadeite Lady. We have a question here. Really quick to veer off for a second. With Dad's latest filing, and I guess this question is to both of us, or maybe we'll let you answer. Do you think the judge will dissolve the conservatorship on the 29th, or just remove Jamie as a conservator? Thank you again, Jadeite Lady. What do my personal opinion is there's like a greater than 0% chance, but it's not likely. That's kind of what I'm going with right now.
Yeah, so I did a video on that yesterday on my channel, and because I've given a lot of thought to this, and Yeah, it's possible. The court could say, hey, dissolve the whole thing, and Britney walks out the door completely free. Um, what I think is maybe more likely is the court says the temporary letters for Jody Montgomery, the conservator over the person, they're set to expire October 8th. So hey, let's just not renew those. So October 8th, all the powers over her person, which to me are the most offensive, go away. And then that would leave the powers over her state or finances, and hopefully that would be a temporary conservator that would wind that up if it's not eliminated completely on the 29th, but somebody to wind that up other than Jamie. The problem though is that Jason Rubin bowed out, and Matthew Rosengart has not nominated a successor. I think he would have to do that this week to be timely. So that's a gamble or strategy decision that Rosengart, I'm sure, is thinking about. Is that does he nominate a successor to give the court all those options, or does he to go in for the all or nothing move, which is, hey, just terminate the whole conservatorship on the 29th?
So from what I understand, the court does have the power to just appoint a conservator, like kind of like it did with Sam Ingham. Is that your understanding? Is that how that works? So even if Matt Rosengart, like let's say Matt Rosengart doesn't file any replacement, person instead of Jason Rubin, is it still possible, not likely, right? But is it still possible legally for the judge to say Jamie still has to go? Too bad, so sad you didn't nominate someone. I'm going to put someone in. Or do you think, strategically Judge Penny is going to not do that again?
So the court could. I mean, I'm sure there's a list. I mean, that's how Ingham got on there. There's a list, right? And
Yeah.
it's like, so we don't really want the judge picking from the list, but the judge could do that. And but what I'm worried is that Jamie's strategic move was to take advantage of this uncertainty and to think like, hey, the conservatorship's going to end. Everyone agrees. We just need like this gentle wind down. So keep me in charge here. We'll wind it down, no problem. And then the judge is like, yeah, that makes sense. Why would we switch somebody out temporarily? It's going to be over with anyway. And then Jamie drags his feet, and we're into this for another year while he's still winding it down. I think that's his strategy. So the thing is, Jason Rubin, yeah, he got roasted for some stuff, but this guy was handpicked by Rosengart. Who do you want? Do you want somebody who was handpicked by Britney's lawyer, or do you want Jamie Spears? And so the next
Yeah.
person that comes in, the same, they're going to have baggage. There's no way anybody at this level is not going to have baggage and lawsuits and all this stuff. So I'm hoping they just get somebody in there that Rosengart trusts enough. Anyone's better than Jamie, I guess is what I'm trying to say.
Yeah, I guess I would need to really look a little more. Like my reservation with Jason Rubin wasn't like the particular sort of factual allegations against him. It was just kind of like um I felt apprehensive to say like, "Oh yeah, let's fully get behind this person," because first of all, we don't really know him. He was handpicked by Rosengart. There might be stuff about him Rosengart doesn't know, right? So we don't really know. And then the second thing was I just felt a little bit conflicted about like sitting here participating in the legal fiction that Britney needs a conservator. And so I just felt like, then I find out this other stuff about his mom and things. But anyway, we already kind of diverted a little longer than I had thought. But I do appreciate your insight on that. And also, I think it just demonstrates, right? Like people can disagree about these really important issues and say, like, I see where you're coming from. You see where probably I'm coming. I don't know. Maybe you don't. Maybe you think I'm a moron, which is you're right, I guess. But yeah, I mean, we all have our different reasons for doing things and such. So I wanted to get back to your earlier conversation. I wrote this note down about like when you were talking about the media matters. I think you said it was 500. I always say it was about 500,000. It's $541,000, give or take, in media matters that Vivian Lee Thorin's law firm, Holland and Knight, charged to Britney Spears' estate. And that's not legal fees and legal bills and things, right? This media matters. In your experience, if you have any here, which I'm assuming you do, but what types of things would they be charging for in media matter? Like, I don't know what that means. Like, I'm assuming, and I'm just making stuff up off the top of my head, that they have like Instagram accounts and like they're on social media looking at what people are saying about the conservatorship, and they're maybe even like coordinating with certain media, and maybe even paying for stories if that's a thing you can do. But I mean, I don't really know. So do you have any insight or experience or into like what the list of things would possibly look like?
Yeah. So the first problem that I have with this is that it's on a legal bill. So we're lawyers. We run a law firm. I can charge time to a client for work that there's done by attorneys or a paralegal, and that's about it. And here we're seeing this law firm putting on its legal bill work by a non-lawyer. You go to the Holland and Knight website, you see the crisis manager, not a lawyer, and they're charging that. So to me, I treat that as disguised legal fees. It's a fake bill. And so right there, it's improper for the firm to have done that and to disguise it as legal bills and charge the estate for it. Then to answer your question about what is this person doing? Well, I'm sure going and monitoring social media, potentially commenting on stories with accounts that were created, and I've seen that in another celebrity story that I've worked on where that has happened to try and push the public opinion about something. But
If I could
also
interrupt
here, and
you
I think
really
more
quickly.
nefarious is um,
Go ahead.
the actually contacting reporters and saying that I have information on behalf of the conservatorship about Britney Spears. This is what's really going on behind the scenes. Please print this. And that perpetuated the conservatorship by making it appear that Britney was, so disabled or whatever they were trying to make her out to be that she needed the conservatorship. So that to me is a lot worse than kind of spoofing an account or just monitoring stuff. It's actually planting stories that information should have never been shared outside of the legal case.
So, okay. So now I have two questions. With so in another case, just to clarify, you saw where a party to this case created a social media account for the purpose of commenting on this case, on their case publicly, and trying to persuade people to think a certain way about it.
Yeah, so I mean, you have to think about if it's a celebrity going through a legal issue and they're a major established celebrity, they have a PR machine. I mean, this is their life. So if they're going through something and bad, then they go into the crisis mode. And there's ways of going about it. One would be just directly getting on there and saying, "Hey, I'm the celebrity. I'm going to go tweet about it." But a lot of times they don't want to do that. So then they would have accounts created that would basically push that story and that they want to put themselves in this light, and then to basically lash out against anyone who's commenting. And so as a legal commentary, I've done this like say about 15 years now. And I try and stay very neutral, in the stories, but sometimes I am definitely skewing towards one side because I just believe one side is got it right and the other side's got it wrong. And in this particular case, I've definitely saw the backlash that was created because of the side that I was skewing towards. And again, I can't name names but even to the extent of a former celebrity client that I had represented being contacted to ask me to stop commenting towards the other side. So there's a lot of attempts to basically stop people from saying things that they don't want said, and I guess maybe hey, that's their right. Um, but it does impact the media, and especially like if you're a major news outlet and you want to curry favor with this particular celebrity because you want whatever, you want the inside scoop, you want the first news coming from this celebrity on their new album or new project or whatever, you're not going to go and blast them about their divorce. And you may even say, hey, let me print some positive stuff about your divorce so now I can get something better from you on the entertainment side that we're more interested in.
Yeah. That's actually, yeah, that is something that I've spoken about, I think on this channel before, where, you'll have these huge managers, the likes of, perhaps people like Larry Rudolph or Adam Lieber, who worked both with Britney as her managers. They may manage, 10 of the biggest names in whatever music at the time or a certain genre. And if you don't talk, I mean, listen, I'm not accusing anyone of doing this. I'm just using it as a hypothetical, right? Let's say Larry Rudolph or someone like that in that type of position were to tell a reporter at wherever, CNN or whatever, listen, if you don't run this positive divorce story about this client, then I'm not going to give you any more inside scoops about any of my other clients 2 through 10. And I feel like whenever we say things like that, as people who don't have experience seeing it in real life necessarily, it's like you get dismissed as a conspiracy theorist or as someone who's just being so far-fetched and that they're not even using logic. And to hear you kind of confirm that definitely happens, it makes me even more mad about being sort of dismissed all this time.
Well, and it's not necessarily that overt, the this for that. But and I've seen this with my cases, and I never talk about my own cases, or very, very rarely talk about my own cases. And so when I'm handling a celeb case, I'll be contacted by the media, and they'll say, like, what's happening, or what is this document, or what's happening next. And I know that there is a very subtle deal that could be made where it's, if I leak the information, that they would then print my name and publicize me basically in that story. And that's how a lot of attorneys get their name, because they leak information and all of a sudden their name is now attached to that story. And it's kind of obvious to know, because if you look at a TMZ story and they're all of a sudden talking about some source and leaked information, and all of a sudden they're blasting the name of the attorney, well, why do they need to put, who cares who represents so and so? That's not news. It's not news that I
Yeah,
represent or somebody else represents. That's not part of the news story. If you're a journalist, it's like it's an irrelevant fact who the lawyer is. So why are
that
they
is a
mentioning who the
great point.
lawyer? Well,
That is a
because
great point.
they're paying off that's their way of paying off the lawyer. Not every time for sure, but that's the thing that I've seen. And because I don't talk about my clients because they want to have privacy, and it's like this super embarrassing for them. So it's like I generally am not going to give statements unless the client authorizes it, and therefore a lot of my stuff is super quiet, and that's the way I want it. But then you see the other ones, and it's usually for the attorney representing the non-celeb in the relationship. Their name's all over the place. Why is their name all over the place? Because they gave the media what they wanted, and the media gave that attorney what that person wanted.
Wow. I mean, when you put it out like that, it sounds like, oh yeah, obviously, but truly, like, you just don't think about it until you have to, I guess. Yeah, I mean, it makes sense, but yeah, why do you need to put the lawyer's name in the news? What's the point of that? Yeah, good point. I mean, unless it's like some other, like, unless it has some news value to it, right? Like, oh, also represented like this crook or whatever. Um, wow, I'm learning so much with this. We should do this more often. So I wanted to give you a chance also, Chris, to talk about um, what your next steps are going to be, and kind of maybe even like a little bit, like, what were you thinking whenever you saw that rejection happened? I know that, I saw on Twitter, you did not receive, as the person who files, the lawyer who filed, you didn't receive any notice that this was even going to be being decided on or anything. Like, you just kind of found out with the rest of us that it had been denied and kind of, I guess, go from there.
Well, they put it in the mail, and that's that's so there was a little bit of a delay, and I did see it was brought to my attention that it was on this court's calendar for Thursday at 3 p.m. that all of a sudden we see this hearing on there. And I think that's just the court's way of keeping track of the fact that it's going to issue a ruling. And I had no thoughts that this was the ruling in the USA Today request. I figured it was having to do with Jamie's petition and doing a status conference order to say, what are we going to do on this on 929? Because honestly, that was the most important thing that Judge Penny could be working on at that moment. But yes, it did come out. Now, I did ping the court last week, and I basically said, hey, I need a ruling on this thing, because my fear was that the court would run the clock on me and not give me a ruling, which would then leave not enough time for me to go to the Court of Appeal to have this thing potentially reversed in time for 929. So I said, hey, you guys got to give me a ruling, or I'm basically going to treat this as a denial and appeal it. And so they did give me the ruling on Thursday, and there's some unexpected stuff in there, but the decision is, hey, they spent 4 pages on it. I appreciate and respect the time that was given. I don't think Judge Penny alone would have written this. It would have been the court leadership, because I wasn't just saying, hey, give us access on 929 in Britney's case. I'm saying restore audio access in every one of your courthouses in the county of Los Angeles for every non-confidential case. So Judge Penny can't decide that. It's the court leadership, it's the presiding judge that I am sure had either a hand in directly writing this or somebody else, no question about it. And so what I'm trying to do, again, it's not just Britney's case, and this is bigger than Britney's case. This is about having access to all cases, because, again, if this can happen to Britney Spears, it can happen to anybody. And sunshine is the cure here. It's the judge knowing that somebody may be listening on that phone line when they're making a ruling that's going to keep them on track. That's the transparency that we need. And this can be Britney's legacy, that it's like she suffered a lot. She's still suffering a lot going through this case. But maybe, just hopefully, we're going to learn something as a court system from this and not let it happen to somebody else. And if we can get the access back, so it's not just the people who can travel to the court and find a seat and sit there and take notes, that people all over the world can be listening to this, and the court, you have nothing to fear from that happening, may keep them honest enough and so they don't issue orders like this in secret to somebody else.
And in their rejection, they wrote out this whole little thing and all, and we went over it, I think, on at least Instagram Live on Insta. But they said something about polling. They did a poll of the public to see who was going to be interested in coming. I didn't get any poll. Did you get a poll?
Yeah, I was surprised. The bottom of page 2 in the ruling, it says, hey, the court says we got 65 seats, which fine, it's a lot of seats, and in the courtroom, and they did some kind of survey of the media to see who's going to come on September 29th. And the implication was that there weren't a lot of people who responded, and there's plenty of seats, so nothing to see here. There's not any kind of limitation on access. So that's why we started tweeting about that. I was like, gee, I didn't get that. What are you talking about? So we eventually got it. And it was sent
they
out.
even went even one step further, Christopher. They said they did that poll, and USA Today said they weren't even going to come. So they made it look like, once this does get to appeal, that's kind of like misleading. I don't want to get too involved in commenting on an open case and all, and you don't have to at all. But in my opinion, from a just outside non-legal opinion, that's a little bit suspicious, because they're sitting there saying, well, yeah, USA Today didn't even say they're coming. So they almost made it look like you're making this big deal out of nothing, whenever they didn't actually send out anything to USA Today that we even know of. You know what I mean? Calling, it was like a call out, like USA Today isn't even coming. So I don't know why they're so upset. And it's like, that was a fake survey. Where was it even posted?
Yeah, so I suspect we may see this again here on the appeal, and I'm prepared for it, because I do have now the notice that was sent to the media, and so this is a completely ill-conceived survey that they attempted to do. So so they sent out a notice give to selected media, so we don't even know who was on the list. It wasn't the public; it was just whatever media contacts that they decided to send it to. Number one, so very limited audience. Number two, they gave the media 2 days to respond. 48 hours. Do you want a seat on 929 for Britney Spears? And number 3, right at the top of the notice says, do not publish or distribute this. So like, what, why not? I mean, it's the court. This is like, the thing is like courts, these are public proceedings. The court is part of our government. Why are you doing stuff in secret? Why are you telling reporters like you can't tell somebody else about our secret survey? If you're really trying to gauge interest, it's not just the media, it's the public. Send out a public notice. You go on the LA court website, because I've been looking at their news releases and I'm using against them actually in the appeal because they're saying all
Yeah,
kinds
I
of
saw that.
inconsistent stuff. I'm looking
Yeah.
at their news releases. They're sending news releases every day. Put out a news release. Hey, public. Hey, media. Do you want to attend? Go and share the news. Please spread this because we really want to know. No, you don't want to know. You want
You
to
don't want to
create
know.
a fake survey. And that's what they did. And I'm gonna, I'm gonna call them out on that in
That's
obviously a
good.
very delicate way.
Yeah, well, we're less delicate here, so we'll be doing this side of things. But I'm looking forward to reading, hopefully that, well, which court are you going to be appealing to? Because I know it seemed as though you were making a sort of federal argument. Is this a state grant? What do you think? Also
Sure.
don't talk about it if it's going to give away your strategy or whatever.
No,
Sure,
no, no.
love
Yeah, it's all open. It's so the next higher court is the State of California Court of Appeal, Second District in Los Angeles. So it's a state court of appeal. It's the supervisory court for the LA Superior Court. So that's where it goes next. If that court denies it, I could potentially take it to the California Supreme Court. They don't have to review cases, so I'd have to convince them that this is worthy. And so I could potentially take it there. I don't know, USA Today, and I would have to say that that's worth taking to the highest state court, and then potentially could go to the United States Supreme Court. But I don't know, like, again, we'll take it one step at a time, and I would learn from each one because I wanted to know what the LA Superior Court said. I mean, hey, these are very smart people, and they spent 4 pages of time or words working on this thing. And so each level here that we might go through, I would learn and say, well, hey, maybe they got it right. I'm not saying I know everything, but the LA Superior Court ducked the issue. There's a constitutional argument that I was raising for public access, and they ducked it. They said no, it's not there's no constitutional right to anything that you're saying. We have 65 seats. That's all we have to provide. And by doing so, they avoided getting into what we call a strict scrutiny analysis. They said we don't even have to justify why we pulled the plug on remote access. We don't have to justify why we're not letting people listen into these because we just simply don't have to. It's not a constitutional issue. Well, I disagree with that. I think it is a constitutional issue. And so that's what's now given me the opportunity to go to the Court of Appeal and saying, hey, I kind of think it's a constitutional issue. Don't you?
I mean, I do. We have other folks in the chat saying, especially in the pandemic, like people who are at higher risk of contracting COVID, even people who live 3 blocks down from the courthouse, even if they're physically located in California or LA, they could have harder, there's equal protection issues, I guess. I'm not a litigator. I don't really know who has standing in things, but that seems like, I don't know. A lot of times I get caught in this trap of trying to use common sense instead of looking at what the statutes say. And a lot of times, I mean, I'm a little baby lawyer, but a lawyer nonetheless. And I still get befuddled whenever I see things going so far against common sense. Like you said, right? If you're putting out a public notice, why would you put don't share this with anybody? Then it's not a public notice, right? So it's not a public notice. But a lot of times this all happens in secrecy and in the dark. And there aren't people who are willing to chase down what's right. And I really appreciate USA Today going for it. I really appreciate you going for it because this is how the laws are shaped and made, because we have to push back whenever there's this, like, frankly, tyranny or whatever you want to call it, going on. So yeah, also I want to circle back to, okay, well, let's just finish this thread here. So you're going to appeal it. We don't know, what happens on appeal, and you never want to make any sort of predictions or whatever, but this would conceivably be happening probably pretty quickly given the timeline. like a
Yeah.
decision from the
So
appeals
this
court?
week I'll file with the Court of Appeal what's called a petition for writ of mandate. So it's asking the higher court, the Court of Appeal, to command its lower court, the Superior Court, to reinstate this audio access program. And again, I'm going to give the Court of Appeal all kinds of options. So I'm going to say, hey, go ahead and order them to reinstate it immediately on a temporary basis while we, spend what could be a year or 6 months arguing over these constitutional points. But in the meantime, flip a switch. What's the problem? You have the access, you got the vendor, you got the program. It basically didn't cost anything. Tell them to flip the switch, turn on audio access. We can all listen. It's not going to end the world for you to allow people to listen in on your court proceedings. And then we can argue whether it's constitutionally mandated for sure later on. So that's going to be one ask. So we'll see, again, how the Court of Appeal views this. But I will tell you that the Court of Appeal live streams all of its hearings. So in that Brad Pitt Angelina divorce or custody proceeding where where she got rid of the judge, there was an appeal on that. Everyone could listen to that live through their live stream. And then if you wanted to order a recording of it, you could order a recording of it. So this Court of Appeal is going to be deciding our request, feels that the public should have open access to its proceedings. So I'm hoping that it will think its lower courts also need to do the same.
So, thank you, Low Child. And that was a question I was also wondering. So I do want to ask Christopher. So let's see if I can show this one. So Low Child says, thank you for your dedication and reporting, Christopher. Loved your filing, how you included your backup plan to appeal. Yeah, like how you kind of like foreshadowed you were definitely going to not just let them make this decision and not have any oversight, which is good because they usually don't. Usually they make whatever decision they want, no oversight. And then Low Child says, what % chance do you think as of now the press will have access further than just pen paper on 9/29? Before you answer that, and if you don't want to answer it, like some of these questions, Chris may not be able to answer. So it's not, nothing personal. There's just certain ethical things. But I kind of think, Christopher, that they're going to re-implement this program, and because cases are getting worse and things like that, at some point it's going to stop being arguable that they're actually acting in anyone's best interest by doing this. And I think they're just going to re-implement the program and say it had nothing to do with your filing so that they can avoid really having to answer for the constitutional questions. But I just made that theory up out of nowhere. So what do you think?
Well, sure. So, I get asked a lot, by clients about what % chance do I have? So I always avoid giving percentages because it gives the illusion that I actually know what I'm talking about or that I have some kind of mathematical precision to these things. So I don't give a percentage. I can tell you that this writ petition that I'm filing, they're mostly denied. So you can look statistically that whenever you go to the Court of Appeal after losing in the trial court level and try to have this the higher court reverse, that statistically they're almost always denied. So those odds are against me and everyone else who does something like this. But I do think that the interest in this story itself is so important, that the pandemic is still upon us. And that was the main reason why the Superior Court is saying we got rid of the remote access, because it's no longer needed, right? Because the pandemic, we all know, is gone and we can freely go about the country and not worry about anything. That's what literally they're saying in there. There's no reason for this anymore. And that's why we got rid of it. We're not trying to punish the public. It's just that it's totally fine. Come into our courts. There's no social distancing. Well, we have the tweet, and that's one of the great things about being on Twitter. It's like they put a tweet out there, the LA Superior Court, do not come to court. Not really safe for us to do so. The LA Superior Court also, in one of its press releases, had to extend the deadlines for criminal defendants, because, criminal defendant has a right to speedy trial. So they're saying, hey, criminal defendants, so sorry, we can't really give you these speedy trial stuff. We got to extend things because this new COVID, all the outbreak, it's crazy. It's worse than ever. So we really can't do this stuff that quickly. That's what they're saying right now to criminal defendants. That's what they're saying to the public. Do not come to court. But then when we say, hey, could you turn the little phone thing back on for us? Oh, no. You don't need that. You just come to court. So which one is it?
Which one is it? Yeah, no, I mean, I like that's again, listen, everything you just said, first of all, I hope you're going to include in your appeal. And second, it really does just reinforce what I think that they're going to have to do because their hands are going to be completely tied. Like I said, I mean, what you just said confirms what I predicted was going to happen, which is they're going to reach a threshold point in the severity of the pandemic where they're going to start to be very obviously not acting in the best interest of the public by saying, no, come to court, get on a bus, get on a car, get in a train, cross state lines, like whatever the case may be. They're really I mean, this is an attractive nuisance of sorts, right?
Mhm.
People are coming to this. People are coming. And so if you're going to make it even harder to access, even more inaccessible, then I think that you can anticipate that you're going to be facing other lawsuits in the future for other things. So I wasn't planning on talking about this, but now that we're here and I have you, I think it actually could be really interesting if you have any opinions. Actually, no, you probably will have opinions because your specialty. But people are asking a lot about Britney Spears's engagement. There's been a headline that Jamie Spears is searching for a lawyer to do a prenup or something. I had a pretty specific contractual question, but also just wanted to hear your opinion on this generally. So Brittany doesn't have the ability to enter into business contracts legally, from what I understand. She can't even, sort of like do a financing agreement on a car or anything like that under the state of California's laws, but she can legally get married. And I mean, I learned on the first day of family law that a marriage is a contract like anything else, but it's different in some ways. So how is it, right, that you can get married? Because I'm thinking about planning a wedding eventually, right? And it's like, well, you got to make contracts for a wedding. You got to go to be able to make a contract with a venue. You have to if you're going to finance anything, if you're going to, you're going to cater. How do you get married in 2021 and not have the legal ability to enter into a contract? And how does the law sort of reconcile that marriage is a contract and a conservatorship setting?
So yeah, apparently her right to marry's never, been taken away. She may not have understood that. And that's part of a bigger theme here is, and this is what's really disgusting about some of the ways that they've treated her, because they'll say like, oh, on paper, you've already had the right to marry. On paper, you've always had the right to make medical decisions. On paper, you had the right to check yourself out of the mental health facility. And I'm sure if we looked at the paperwork, that's probably all true. But what did she understand? What was she led to believe? And I don't believe she understood that she had any of those rights. And like I've talked before about the mental health facilities, they said, oh, she had her children visit her. It's like, well, who in the world would have their children go into a mental health facility for a visitation if you understood that you could check yourself out? You just say, no, I'm going to check myself out. I'm going to see my kids, and then I check myself back in. So that tells me she
And we
didn't
we
understand.
also heard Brittany's words herself. She told us she couldn't leave. She said it's really terrible to sit for 10 hours in a chair every day, especially when you can't walk out the front door. She couldn't leave. Even legally, if she could, she knew or she understood that she could not leave, like you're saying.
I think that's right. And then, like you're saying, is even though legally she has the right to marry, so I guess she can go to the clerk's office and do a civil marriage thing, and there you go. But if she wants to have anything paid for, her dad would have to approve that. And if her dad's not behind the marriage, then he would just say, well, I'm just not going to approve that. So, okay, so there are some strings attached to it. In terms of the premarital agreement, even if she wanted one of those, that's a very complex contract that I really doubt that somebody under conservatorship could enter into validly. And so and I don't know that she would want a prenup or not. I've had a specialty doing those, and I think the more that I do them, the more I dislike them now. So that's like a really big conversation and a really big important thing, is because yes, she would be coming into this marriage with significant wealth and income that she should protect for the sake of her kids, for sure. But also she's entering into a marital partnership, and she wants to have, an equal partner. She wants to make him feel that he's an equal to her. And if you're entering into the marriage with a whole bunch of conditions, sometimes people don't feel like they're really entering into a marital partnership. And so I've had these difficult conversations where people want a prenup, and they'll ask, like, well, I'll ask them, it's sort of a trick question, but what's your goal? Oh, I want to be protected in the event of a divorce. And then I'll say, well, I was surprised by your answer. I thought you wanted a marriage that would last for life. Oh, well, yeah, of course I want that. Well, how is this agreement that you want me to draft meeting that goal? And how is maybe this prenup that we're going to do maybe not going to serve that goal? So these are really important conversations that she's going to have with a lawyer. And I don't think she can do that while she's under a conservatorship.
Yeah. Well, the way that, pre-marital, and, this is law school and you practiced it, so it's different sort of context. But the way that premarital agreements were explained to me in school was, it's a you sort all this stuff out, and then the professor said, nobody wants to get divorced when they're planning their wedding. But, people come from divorced families and such, and they think, well, could have been better if we did this beforehand. And so the teacher said, think of it as a way to decide what's going to happen in the event of not only a divorce, but a death or anything else, while you still like each other, because sorting it out on the back end after the irreparable damage has happened is going to actually cost you a lot more money, probably a lot more emotions. And so, like, I guess I do have a sort of benign view of premarital agreements because that's how it was sort of explained and described to me. And you said, you're in your experience, the more you do them, the more you dislike them. So maybe that has not been explained to me in the appropriate way. But what is Jamie? And, like, let's pretend that this headline is real and Jamie Spears is out hunting up, searching for somebody to do a premarital agreement. Would Jamie Spears be able to enter into a prenuptial agreement for Britney's finances as conservator of her estate? I mean,
Yeah,
how
it's
does it
totally
work? How would this happen?
it's totally bizarre, and I guess technically it could be done. And I'm not suggesting that she would get married without a prenup. I'm not saying that at all.
Sure.
What I'm suggesting is that not all prenups are the same, and so
Yep.
they're a very complex agreement. There's no off the shelf deal, and so it's a give and take. There has to be consideration or a trade here, that if they want to have a healthy relationship while still protecting her, is all I was trying to say. But to have her dad involved would just be so creepy and weird. And the way that the California premarital agreement law is now is it's anti-prenup. So actually prenups that were made in the year 2002 or later are presumptively void. And we can thank Barry Bonds for that, because he made this horrific one-sided prenup right before marrying his wife, who barely spoke English and didn't have a lawyer, and had her sign an agreement that said, if we ever get divorced, you get nothing. And then they did get divorced, and it was challenged, and it went all the way up to the California Supreme Court. And at that point in time, pre-2002, we basically looked at prenups like any other contract and said, hey, you signed it. And so they said, thumbs up, you get nothing, Mrs. Bonds. And the legislature immediately reacted to that and said, we never want to see this again. So they said, now prenups are presumptively void in California.
Wow.
And
I
so
did
for
not
me
know
to,
that. When did
yeah,
that happen? When was this?
so bonds came out in 2001, and the legislature immediately changed the law on premarital agreements in California. So effective January 1, 2002, it's presumed that a prenup made in California was not made voluntarily. And unless the proponent, usually the one that I'm writing the agreement for, proves a whole bunch of facts, it's almost impossible. It's very, very difficult to make a valid prenup in California because of all these things. You have to have a lawyer. You have to have the ability to consent and understand. You have the 7-day cooling off period. They've made it extremely difficult to make a prenup. So to think that Britney Spears could go through this and have her dad, negotiate and sign off on this thing for it, it's just no. I mean, and there's no
So
reason for her dad to be involved.
I'm understanding, just so I'm understanding this correctly. right now, today, sitting here right now, prenuptial agreements, which is, how's that different than a premarital agreement? I'm not sure. You could tell me after I make sure that I got this right. Prenuptial agreements are presumptively void in the state of California right now, unless you can prove a bunch of really hard to prove types of things. I had no
Yes,
idea. This is brand new information to me. I
yes.
had no idea. So what
If
do the
they were
rich people do over there?
so that rule applies for ones that were signed January 1, 2002 or later. So ones that were pre bonds. They're we can't change the law and invalidate all those, but ones that were made, from 2002 or later when this new law went into effect are presumptively invalid. And we have to then prove all these facts to make them valid. And that's why it's, Kelly Clarkson, proved hers. It's not easy. It's not impossible either. And that's why we see these agreements like, I charge a lot of money to do prenups. So they're very, very expensive because it's a very high skill. And to make them valid and count when you need them, you have to jump through a whole bunch of hoops. So my prenups are 40 pages long. And, so this is very difficult, but not impossible to make an agreement. And basically the reason is that the legislature sees these agreements as being harmful to spouses, traditionally women. And they feel that people will sign a premarital agreement entering into a marriage thinking like, hey, I'm in love, I'll never need this before, or I really don't want this person's money, or I don't want to give the impression that I want this person's money, so sure, I'll sign this without even reading it. And then they're giving away very important rights. And then after particularly a long marriage, being left, possibly with nothing. And so these are become disfavored in California.
Yeah. I mean, the circumstances you described definitely make me feel more sympathetic to the people who are in a position to be kind of, here, sign this. I mean, we even see it in Britney's case. We saw it. Iggy Azalea came out and said, even in Britney's case, like, they approach you and they say, here, you have 5 minutes until we're going on stage, sign this NDA. And it's like, oh, shoot, like, should we really want to enforce contracts like that? No, that's why we have duress statutes. But I do think that the law has, I mean, just from this Socratic method, people I had to listen to talk about this before, right? Like, there is this sense of kind of blaming usually women, right, for being stupid or not doing enough, should have done her research, whatever. And it's like, on the ground, that's really not how it goes. It's usually those people that they're, being talked about like that are the people who don't want to cause a big scene and say no, I'm going to make a big deal about this. Like, okay, I'm just going to sign it. And then later those people are the ones who get kind of messed over or whatever. That's very insightful to me. I had no idea about this Barry Bonds thing. I'm writing a note right now because I definitely want to look it up. That is really so. Basically, what they do then in California is they hire people that are very, very, very good at prenups, right? Like, that's your specialty, and you just have to be able to know all of the ways that someone could possibly try to get out of it. So you just button those up before it ever even gets to litigation. Then,
Yeah, it's basically getting a divorce in advance of the marriage.
getting a divorce. Well, yeah. I mean, when you put it that way, I definitely align with your views of why do you want this prenup? What do you really like? Because to go through this process of putting it together is even going to be you're going to have to answer some questions. Yeah. Okay. Yeah. No, I did not know that about. Are there other states that have that what is it?
No,
Considered to
so
avoid
we're the only state who's done that. So there is a uniform act that most of the states have adopted, called the Uniform Premarital Agreement Act, that makes prenups enforceable. Is actually the aim of that act is to make these enforceable, and that's the law that we had in California when they gave the thumbs up to the Barry Bonds prenup. And so we're the only state who has basically said we hate prenups.
That is news to me. Wow. Well, you learn something new every day. I mean, I love talking to other lawyers who have been doing this longer than me because they definitely know. So yeah, okay. So to wrap up the engagement and marriage and all of that talk, Brittany technically has the legal right to get married, but really, if you want to see, a wedding, like a real wedding that we would associate as a wedding, then Jamie Spears is either going to have to agree to pay for it as conservator, or it's not really going to be able to happen until he's, the conservatorship is over. I mean, how does Britney enter into that's my question. How do you plan a wedding? Does Sam Asghari got it? And just logistically, does he have to enter into all the contracts? Or like, how do
Yeah.
you say that someone has the legal right to get married if they can't enter into contract? Like, how does the law reconcile with those two things happening simultaneously?
Well, yeah. I mean, she can go to the clerk's office and be married, today. I mean, or what? I don't know whether it's however all that process works going down the clerk's office, but she could go get a marriage license and be married. But yeah, anything that she'd want to put on a wedding, that would have to be under a contract that either Jamie Spears would have to sign at the moment, or Sam would have to do and fund. And to me, it's like she's got to get. I mean, I would hope that she would finish off this conservatorship thing first, and then get those freedoms back, and then look at the prenup, because certainly indicated here for her case, because of her wealth and all this stuff, and she has to protect her kids in the event of a divorce. So there's a lot there, and to me, I would like to see her kind of take that one step at a time, because she's got to get out of this legal mess um, before creating a very serious legal obligation in marrying somebody.
It's kind of like a paradox how the law can recognize this sort of fundamental or inalienable right to get married, but it kind of ignores the fact that marriage is a legal contract. And I saw someone said, I got married without contracts, and CC said that, sure, you can, and that's, no less valid in your heart. But there are certain legal protections that you get by being a spouse, like certain, there's always the big example of, going in the hospital room, but it's other stuff too. I mean, there's tax implications and other things. You get benefits in some ways for being a spouse legally. And so I'm having a hard time understanding how the law can recognize, oh yeah, you have this fundamental right, but the fundamental right is to enter a contract with another person. That's really what it is. Enter a certain type of relationship. And so it is, I understand why they're doing it, because it's constitutional and you can't get around it, but it kind of makes you think like maybe what it's kicking back on and implicating is perhaps also unconstitutional. I don't know. I'm just pontificating. I get so little opportunity to do that. But do you?
No, I
See what I mean?
see where you're going at it, because it's like when we get married, we're taking on massive obligations, and also getting massive amount of rights, and so that's going to apply during the marriage, upon divorce, or in the event of a death. So if Britney Spears were to get married next week, and then if she passed away, Sam would be her surviving spouse, and he would inherit from her. And so how would that interact with what she wanted for her kids? So she would need really an estate plan and a will to figure out, to make sure her kids were protected in the event of a death. If they were married and then she got divorced, she would owe him spouse support, alimony. If they had a kid together, it'd be child support. If whatever income she earned during the marriage, he'd get half of it. So this is the most serious thing she could be doing, which I see what you're saying. The law is like, oh yeah, sure, fine, go into that. But if you want to like sign a contract with a wedding planner, no. You want to have, some money for a caterer? No, you can't do that. But you can take on all these other, really, really serious rights and obligations without any problem with the conservatorship.
Can she even insure that ring? Can she even insure her ring? Like, and again, a ring is not a marriage, but everybody knows it is a huge component of it in the United States. So like, it's all over the news and all over the, but it's like, yeah, you can enter into this. You can have all these implications, but like, yeah, you can't pick out and agree to pay for just sliders at the wedding, but you can implicate your children's right to their inheritance.
Yeah.
I don't get it. But listen, I don't get a lot of things. So yeah, all right. Well, we're coming up on an hour. I think that that's probably where we should probably cut it off. Um, did you have any final thoughts, or did you want to discuss anything in particular that we haven't taken
Well, I
on? Like,
think
I know we have our appeal coming up, and we're definitely ready to read that when it's filed.
yeah, so I'm anticipating we're going to see Matthew Rosengart file something this week. So that's, will be the fire drill. We'll all see it come out on the on the docket, and I'm sure you're going to be covering it. But it's I gotta think he's going to file something this week,
What do you
and
think we might file?
well, one could be a joinder in Jamie's petition, because we officially don't know, because Britney has never filed a request to end the conservatorship. So the thing that she did file was she wanted her dad out. So does she now join in her dad's petition to say, sure, let's just end the whole thing on 929? So we may see the joinder. We may
What do you
see,
think?
what's that?
What do you think that I'm assuming, and everyone always says this, Matt Rosengart must have a strategy in have not having filed to terminate the conservatorship. And so does a joinder act the same way as if you were to file a petition on its own? Is it just called something different, or is it something legally different? And
So
why do you think Matt Rosengart wouldn't do that if he doesn't?
yeah, that's the box that I think Jamie's trying to put them in, and to, basically say, yeah, we wanted, and if she doesn't file, if Brittany doesn't file that joinder, then I'm sure we'll see Jamie or Jamie's lawyer commenting on it. It's like, no, not even Brittany wants this. So there's a little bit of a game element to that, but the joinder in it would just be a statement in support of, and and Jamie could take his motion off calendar. That's another risk that we face, because all it is a request that he's filed. So he could withdraw it, and
Uh,
you just call up the clerk, say, hey, just kidding, and take it off. So would he do that? If there's a
does it look
joinder
to
in
you?
it, they may say, well, we already have people, the other side, or Brittany, saying that she's supporting this, going forward with it, maybe ask for some alternate relief herself. And now hopefully the clerk or court wouldn't allow that to be taken off calendar. So there's a little bit of maneuvering going on right now, and thinking, I am sure, with Rosengart, to say, like, how do we handle that? And because of legal timing and deadlines and notices and stuff like that have to be given, I really think it has to be filed this week, probably more like Wednesday or Thursday at the latest.
So if Rosengart files a joinder, Jamie can still pull it off calendar, then you just have this straggling joinder, or does that automatically go away as well?
So normally, just with a "Hey, me too" statement, like, I join in, I support the request, I think that the moving party, Jamie, could take it off calendar. If Rosengart says, yes, I support this, and here are some things that I want as, tag along requests for relief, then I think that would put Brittany's request in play, kind of almost independently enough of Jamie's, so that Jamie can't now pull the rug out and saying, I'm not ready to go forward, or I'm withdrawing the whole thing. So there's a game element there. And like I say, we can't trust Jamie. We know that he's not doing this because all of a sudden he woke up one day and says, oh, I love my daughter and I want the best. He's playing a game, and he's going to keep playing it until he's kicked out.
Yeah,
So that's where and I'm sure Rosengart's thinking of all these different scenarios, but
because it isn't just Jamie, right? Like, Jamie has some of the most brilliant game minds in existence probably helping him. Like, people are helping him strategize too. It's not like just James Parnell Spears sitting around like in his RV, like figuring out this brilliant legal strategy, right? Like, this is teams and teams of people empowered by Britney Spears's money.
yeah. And
So I
that they have their own interests at stake now, because, well, I mean, they always did, but there's a lot of attorney's fees. I got to imagine that bill for Holland Knight's probably $2 million now. So there's a lot at stake. They want to get paid,
Do
so
you
they're
think they're
also
gonna get paid?
maneuvering. What's that?
I mean, I have no experience, so I like asking y'all, like in this particular thing here. So, do you I mean, I'm reading Matthew Rosengart. I know I said we were going to go. Now I have all these questions. I'm reading Matthew Rosengart's sort of petitions to kind of say, look, Vivian should probably not expect that or Holland and Knight should probably not expect that they're going to be getting paid a lot of this stuff that they're asking for. Like, I'm just reading it, taking what Matt Rosengart is saying on face value. But do you think that's really a chance that, Britney just doesn't have to pay all these outstanding fees, at least to Holland and Knight, because they're already so disputed?
So yeah, certainly Rosengart's saying the right thing, saying, "Hey, we're disputing this bill and we ain't paying any of it, and they shouldn't have to pay any of it." But courts take care of lawyers. Courts like to make sure lawyers get paid. And so that could be the parting gift saying, "Oh, thank you for your service, Mr. Spears," and, all this kind of stuff, and go and approve the fee bill on the way out the door. Now, Britney can still contest that later on and maybe have a second bite at it, but I wouldn't be surprised if the court wants to take care of the lawyers.
Oh man, I hate to hear it, but I do like to have a good view of what might be coming down the pipe. Okay, we do have. Thank you so much, AW Network. Question for both of you: being realistic, how far can Rosengart go back in his investigation? Can he investigate back to the start of the conservatorship, or can he only go back to a specific amount of years when Goat's left? And I think the answer is just like it depends what Rosengart's actually gonna charge and allege, and is he going to stay in this court or leave out of this court? Like, kind of depends on a bunch of things. But I am assuming if they're trying to go for certain things, they can go all the way back to the beginning and maybe even before.
Yeah, that's the beauty of this, because they with the conservatorship, you got to take the good with the bad, Jamie. And what they did to her is they took away her rights under some theory that she was incapable of exercising any of these rights on her own. And that means that during this 13-year period, she was legally incapable of suing. And because she's legally incapable of suing, the statute of limitations, the deadline that normally applies, that we have to, if we want to sue somebody, we have to do it within a certain period of time, is all what we call told. It's stayed. So
Yeah.
she can absolutely go back, and she actually has a period of years after the conservatorship ends to sue everybody for this. She can go back to February 1, 2008, and even attack transactions that were approved by the court. So the probate code says that if the court approves a transaction, like payment to the lawyers or approving transactions, sales of her property, what have you, that the conservatee, after the conservatorship is ended, can sue to recover the money if she proves that it was a result of fraud, conspiracy, or an omission of a material fact. And I got to think that she's going to be able to show omissions of material facts in pretty much every single one of those transactions, because it's really hard to disclose all the facts. So she can go through, and that's what I'm hoping she's going to do, meticulously, starting from February 1, 2008, sue the hell out of everybody for every transaction that happened.
Wow. I can't wait. Hopefully, like you said, they've just put somebody in there as far as a replacement conservator. Because, like you said, I mean, almost anybody is better than Jamie. We don't have to love them. We can be critical of them, but kind of like let them get in there and start looking at these transactions, because you can't sue somebody for something you didn't find yet, right?
Mm-hmm.
Okay, cool. Well, thank everybody for coming out today. If you did not already go subscribe, please go subscribe to Christopher Melcher's YouTube channel. It is linked down below, and you should definitely follow him also on Twitter. I'll put your Twitter handle down there below too. I had a great time. Very informative. I feel like I need to process some of the things I learned. Thank you so much for sharing your knowledge and your experience with me and us today, Chris. And I really hope that you come back very soon, a lot of times. And yeah, so facts ain't defamation. Everybody go subscribe to Christopher's channel and follow him on Twitter. And we will see you all back very soon. Hopefully we'll be getting a filing from Matt Rosengart in the very near future, this week, hopefully. So see y'all later.
Thanks.
Thank you so much, Chris.